Hello, my wonderful friends. Sally the Seeker here. Hope everyone is doing well. I'll just go ahead and get this started. I'm picking up where I left off the last time because now it will be time for Detective Casey to testify his second and final time. And of course, Brooks is going to object all about it and why does he need to come, blah, 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 blah. You know, all that stuff. But it definitely makes for some interesting entertainment. So we are going to enjoy. And I will warn you, I will probably stop often and talk, react, because I have things to say. And I know that most of you are fine with it. You kind of fall in with the rhythm with me and all that kind of stuff. But I understand other people are annoyed. They want to just watch it, you know, without all this extra stuff. But it's more fun for me and hopefully for most of you all. So if, you know, you don't like that, go, you know, and I totally understand everyone's entitled to their opinion, but I would recommend going to Court TV or Law and Crime or anywhere where there isn't people talking a lot, because I probably will, because he just irritates the hell out of me, and I consider it my therapy, and hopefully you all will consider it your therapy too. So without further ado, let's just get on with this clown show, freak show, whatever y'all want to call it.
Darrell Brooks, case number 21 CF 1848. May I have the appearances, please?
Good morning, Judge. Two law firms, Leslie Basie and Zach Woodchow, appearing for the state of Wisconsin.
Good morning, sir. Please state your name for the record.
He can't even state his name.
Make sure I have everything since it's kind of late today.
Keep people
I'm
waiting.
here as a third-party intervener in that matter, appearing as authorized representative for my client. I accept for value in return for value all of the charging instruments in this matter and make my exemption available for the discharge of all obligations and charges connected with this case. I do not dispute any of the facts in the charging instruments and do not consent to being called that name for the record.
All right, thank you. That is noted. The record will also reflect that the individual known to this court as Darrell Brooks is present in person in custody. He is wearing street clothes, specifically a suit and tie and a mask as well.
And don't consent to being called that name.
I understand, sir. All right, I do want to put on the record I gave the parties this morning. It's an excerpt from a judicial bench book on opening statements. It's about a page and a half. I thought it would be helpful to provide to Mr. Brooks as he puts together his opening statement. It has reference to some Supreme Court rules, SCR, some case law, talks about the manner and purpose, scope, and other things. And as I indicated yesterday, sir, I like to call it the roadmap. It's referred to here as a framework so that the jury can better understand and evaluate evidence. It must also be
Sorry, trying to make better adjustments
based
here.
on the law and the evidence you believe is properly admissible. I'm going to further advise you at the time when you do make your opening statement that it not reference subject matter jurisdiction. That is, despite what I know you believe to be to the contrary, it is not a requirement to be proven in this case. It is not a factual or legal argument that is accurate, and therefore I'm prohibiting you from referencing that during either opening statements or closing arguments. With that, I believe
For the record, is this the which you're referring to?
The page and a half is from my judicial bench book. I thought it would be helpful to you as
I accept for value.
have a better awareness and understanding of the manner and purpose of an opening statement. This is what guides me as I preside over cases.
Okay, I accept for value in return for value these documents. I don't know why the reference to subject matter jurisdiction in the opening statement. I'm pretty aware that wouldn't be part of an opening or closing statement. I
Okay, great.
don't get why that's
Wanted to
relevant.
make the
Could it only be because he mentions it like every single time, all the time? Yeah, he acts like he's such a smart attorney. Look, see, even our stable bailiff is done with him. He acts like, oh well, you know, he's almost like Brooks is almost like what's the word? Offended that she would think he would do such a thing, and then he goes on to do even things that are more stupid. But let's go on. We'll play along for a few minutes.
The record clear. So I appreciate you indicating to me that you're aware of that.
Even though subject matter jurisdiction has not been proven on the record.
Yeah, there we went.
And should
Sir,
be
it
addressed.
does not need to be proven on the record. It's established by law and by the fact that, as my written decision indicates, commenced when the criminal complaint was filed in this case. It's conferred by Constitution and by statute.
And who was the complaint filed by?
We don't have time for
Subject matter
this.
jurisdiction has yet
I'm
to
not
be
going to go
proven
down
on the
this
record.
path today. I'm just advising you, you cannot reference that in your opening statement.
That was something I've already had the common sense to know, but also subject.
You don't have the common sense to find yourself out of a wet paper bag. What the hell are you talking about? Look at him. With his Bible open. Probably the Revelation.
Subject matter jurisdiction has not been proven for the record.
And we're still going to talk about it.
All right, next topic then. I believe the state has
Should be
filed a
proven for the record
motion.
by the prosecution.
The objection is noted.
He's so
It is not
cocky
legally
and
sound.
sure of
It's
himself.
overruled.
It's definitely legally sound.
Definitely. He knows what he's
All right,
talking about.
Yet to be
Attorney,
proven.
I'm going to turn to Attorney Opper. They filed a motion this morning.
Yikes.
Has it been pulled through? I probably just need to refresh, but Madam Clerk.
It was served on Mr. Brooks last night in the jail, Your Honor.
All right, go ahead. You can make.
I didn't look at the document.
Uh-huh.
I accept for value, return for value the document. I didn't look at it. So I don't know.
Okay, yeah, I'm stopping again. You know, he always doesn't get all of this stuff, and yet he wants her to read every ICF form, and I call it the idiot complaint form. So, you know, he doesn't ever want to read any, he doesn't want to accept anything that they've sent them, even if it's to help him. But he wants them to know everything about his stupid papers that he's turned in. Just saying.
I don't know what I'm supposed to say to that.
All right, well, Attorney Opper, it's your motion. I'll hear from you.
Your Honor, we are moving to amend the information with respect to one word in the entire document. We're asking to change the location of count 76. The information reads, as it reads right now, it reads at Frame Park. We're asking to change that to near Frame Park. We believe that that's a more consistent statement that aligns with the testimony of victim PPP, Erica Patterson, as she testified in this trial. We're not asking to change any criminal charges. We're not asking to change any dates. It's, I think, a very small change in the charging document. The defendant has been on notice of the facts of this transaction. It's reflected in a number of police reports and Ms. Patterson's recorded statement, which the defendant has copies of. And so I don't think that there's any grounds for a claim of prejudice by this change, and we're asking to move forward with that amendment to the information.
All right, thank you. Any position on that,
Oh
sir?
God, here we
Yes,
go.
First of all, for the record, there were originally 2 charges associated with this one party, and these charges have been charged for the better part of a year. I feel that if there was essentially one word that needed to be changed, it's been more than ample time for it to be changed. Even after one of the charges was dismissed, it could have been, that topic could have been visited at that time for it to change. I don't think changing one word at this point really has any bearing on the testimony or the actual charge. I don't.
Okay, I'm just gonna. I know it's a lot. I will try to behave. I'm trying. But the thing is, what he doesn't get is, number one, he just wants to. He wants to disagree with whatever they bring forth, because his goal is to always be in direct opposition to anything they say, even if it's to help him. I don't think he will ever. I am so sorry about all this adjusting. My thing is wobbling around. Here's the thing. I get why. There's nothing about ample time. Sometimes things come up later on. And I think they're trying to make the distinction at Frame Park versus near. I don't think they were at. So they want to change the word to near. I know he doesn't get that. And I hate to say this, but I have taken creative writing courses, Mr. Brooks. And actually, I have a master's degree in English and creative writing. Not that I always do well, but so when you do that, there's always a lot of editing to do. And if you want the record to be accurate, that's what you have to do. I just had to say that because he's just, he's just being disagreeable. He doesn't get shit.
Understand why emotion needs to be heard about one word. Is then kind of at this point kind of a moot point.
But we got
It's
to
been
see.
charged like this for a year basically. The language hasn't ever been referenced to being changed before.
Oh God.
Yesterday. So what is the significance of this now at this point?
Thank you, sir. Court is guided by section 971.29 sub 2 of the Wisconsin statutes, which provides at the trial, the court may allow amendment of the complaint, indictment, or information to conform to the proof where such amendment is not prejudicial to the defendant. Case law states that when an amendment to the charging document does not change the crime charged, and when the alleged offense is the same and the results from the same transaction, there's no prejudice to the defendant. State versus Wickstrom, 118 Wisconsin 2nd, 339, found at page 348. It's a Court of Appeals case from 1984. And also, I point the parties to State versus Durango, 229 Wisconsin 2nd, 1. And State versus Gerard, 189 Wisconsin 2nd, 505. The first of those 2 cases is a Court of Appeals case from 1999, and then the second of those referenced is from the Supreme Court from 1995. I'd also point the parties to State versus Frey, 178 Wisconsin 2nd, 729, a Court of Appeals case from 1993. As far as whether this is a moot issue or not, I'll find that it is ripe for determination by this court to hear this motion, and that is because the jury ultimately will be instructed similarly to what the jurors were instructed at the beginning of the case. The charges are read. Those are based off of the information, and this proposed amendment does conform to the proof. There is no prejudice to Mr. Brooks. It does not change the charge in any way. It is still the same offense. It's still from the same general information that was indicated in the criminal complaint. So for all of those reasons, I will grant the state's request to amend the information, and the state may file that document as soon as possible.
I have a question about that. So, this same person is scheduled to testify again. What if something changes in the testimony?
I'm not going to answer that, sir. It would require me to speculate on what that situation might be and to give an advisory opinion, which I will not do.
But what happens if that happens?
I'm not going to answer that, sir.
She just told you.
You're asking me to give an advisory decision. I'm not going to do that. I'm not allowed to do that, actually. Okay, so we dealt with that
Makes
then.
no sense.
The
Yeah.
state has not
Much like
rested
yourself.
yet. Will the state anticipate calling any other witnesses?
Yes, Your Honor, as
Oh.
indicated yesterday.
Okay, wait a minute. Okay. I know. Okay, so he just looked up at the ceiling, right? Either to consult his guardian angel or to look at post-it notes he has up there to remind him to ask about subject matter jurisdiction or grounds or sustain or reason for sustain. I don't know. Okay. I feel free to participate if you would like to, and if not, that is perfectly fine. I have my choice of beverage here. Nothing exciting. It's a Sprite. I'm cracking open right now. And every time he consults the ceiling, whether it's to consult his guardian angel or post-it notes, or he also stares up there when he's pouting and trying not to listen. Take a swig of your favorite beverage, or take a bite of your favorite snack, or inhale your favorite thing to inhale, and we'll make it a party. Okay. And I'm going to keep track of how many times he does this. Okay, so here's one. Now don't worry, I promise I will not stop every time he does it. I'm just going to keep it rolling and keep track of it. So there was one. I know y'all are probably like, oh my God. All right, here we go.
We do intend to recall Detective Casey to the stand, and I'd like to make a record in that regard, please.
Go ahead.
Your Honor, Detective Casey did testify once for the state early in the presentation of the matter. His focus at that point was largely on assisting the jury in understanding the layout of the parade route, giving background and contextual information to the jury, the different parade units that were impacted, what they looked like. We showed several videos with Detective Casey just for background and context purposes. He then went on to describe his personal interaction with the SUV as it came through the intersection of White Rock and Main, and essentially that was the bulk of his testimony during his first testimony. We're seeking to recall him now. This is not unusual. It is commonly done in cases. We never excused him from his subpoena. We never asked for him to be excused from his subpoena. We always intended to recall him. We did this so that we can efficiently present the information to the jury. The types of questions we have for him now go more to the investigation itself and his role as the lead detective in this case. There will not be duplication or repetitive questions. I'm not going back to the corner of White Rock and Main with Detective Casey during this round of testimony. We want to ask him essentially about how some of the victims along the parade route were identified. We want to ask him about some of the topics that have been addressed throughout the course of the state's case, as far as identification of the vehicle and identification of the driver. And we need to still introduce the certified bail forms from Milwaukee County for the 2 bail jumping counts. So he will be asked about that. I estimate my direct examination of Detective Casey would be about 20 minutes. So this is not going to be repetitive. It's information, again, that he has as the lead detective in the case to assist the jury in understanding some of the things on the back end that he was involved in, not his role at the parade. So we have been very efficient in our presentation. I believe Your Honor would agree with that. We're not wasting time here, but we just have a few more questions to wrap this up.
Right. Any position from you, sir?
And yes, I do. And I'm going to start with what was just said. The prosecution feels that they've been efficient in their presentation. So it seems like to me an attempt to get more questions in that could have been asked in the first place. If Your Honor recalls, Detective Casey was testifying for quite some time, to the point that we actually had to have a break before I can cross-examine Detective Casey, if you recall. He was up there quite some time. That was more than enough time for any other foundations to be laid, any questions to be asked at that time. And also, from my recollection, he was asked to be excused. So, essentially having him start off and then end it, I feel like it's an attempt to get questions that was maybe forgotten to be asked, answered. And essentially what more could be gained by a second testimony from Detective Casey?
Well, sit back and watch. I think there's going to be a lot to be gained. And he probably knows it too.
What more can be gained that hasn't already been learned? We learned about vehicles and identification by numerous witnesses. We've been through the inspection of the vehicle. We've been through DNA analysis of the vehicle. We've been through numerous things in regards to the vehicle. Even the reconstruction testimony. We've been through all of that. Seems like nothing more than to get extra questions answered that could have been asked from the get-go. As seeing as how he was up there for quite some time and none of those issues were raised at that time, what would be the significance at this point? When it's essentially I should be already presenting my defense at this point.
I think it's pretty ironic that he's talking about how much time he was up there when he goes on and on and on with his cross exams with those, with the witnesses. I think it's pretty ironic that he's saying that when he is the major time waster of this whole thing.
In trial. I don't see the relevancy of it, and to my knowledge, he was excused from.
No, just pipe down. The judge will let you know what you need to know.
It's subpoena, so.
Thank you,
What's the
sir.
relevancy?
Thank you, sir. The court has discretion under 906.11. It's a statute I've quoted with frequency during the course of these proceedings. I've listened to the state's offer of proof. I've listened to the objections made by the defendant. In my discretion, I am going to allow Detective Casey to be recalled for the reasons laid out by the state. As I understand his proposed testimony today, it is not to rehash topics that he was questioned about initially. This has to do with his investigation and role subsequent to the initial contact with Mr. Brooks at the
Apologize for all
beginning
the
of the
adjusting,
parade route.
guys. I just,
And as the state indicated, we'll address certain things, including identification related to the vehicle of the driver throughout the investigation, identification of certain victims. In addition, there are 2 additional charges for which the state has not yet presented testimony, so it's proper
Sorry,
for
guys.
those as
I'm
well.
so
It's
sorry.
relevant, and I will
Bear with
allow
me.
it for those reasons. So the state will be able to recall Detective Casey, and we'll have that done obviously when the jury is brought out. Any other preliminary issues then from the state?
Your Honor, just, I am working on going through our list of exhibits, and I will work with your clerk to make sure that
I can hear him
everything that I'm
clicking
showing
his
was
pin
admitted
insert.
and accepted by the
he
court.
doesn't like it.
Is what she has, so that we can clear that up before we actually rest.
And sorry, the camera just fell again. I don't know what's going
Thank
on
you.
here. Apologize.
Anything preliminary from you, sir?
Yeah, just a quick question about that last thing again. I will be able to re-cross-examine
Oh, yes, you will.
and
Be
is
cross-examining.
essentially anything left off limits to my cross? Or
God.
would
I may limit, depending on where we go, if the questions deal with what he testified to previously.
Oh my gosh, I'm sorry. This camera
Primarily
keeps
to
falling, guys. I'm so sorry.
cross-examine, based on the new testimony. However, 90611 also says this: witness may be cross-examined on any matter relevant to any issue in the case, including credibility. It does say in the interest of justice, the judge may limit cross-examination with respect to matters not testified to on direct. So I'll give you some leeway, and I'll trust the state will make appropriate objections, and I'll rule on them if and when they're made.
because I'm not intending to go too much back into the previous testimony, but I'm
Lies.
thinking a few points from the earlier testimony
I
may
think
come
that's
into
fair.
play, and I just wanted to make sure
I think that's fair.
that wouldn't be a problem.
I think that's fair, sir.
Also, really quick,
Nothing is
I
quick with
did
you.
look over some information provided by the prosecution as far as the pretrial offer that I did not have knowledge of until, I don't know if that was today, Thursday. I don't know if that was Monday or Friday or Monday, one of those days. I've put together, started to, I won't say it's completed, that wouldn't be fair to say. I've put together, or started to put together a counter offer, so I just wanted to advise the court that I was putting that together.
All right, thank you, sir. If and when you do provide that to the state, please let me know so we can make a record of that. All right, anything else? If not, then we'll have the jury brought out.
We do have one last large map here, Your Honor, I'm going to ask, put up and face backwards like we did the other day.
All right, go ahead since the jury's not here.
Okay, I'm trying so hard to get this tightened. It's very loose. He's sweating it. He knows. He knows. He don't want to admit it. He knows. Ugh. Oh God, I'm closing my eyes for this one. Ugh.
Thank you.
That bailiff, I love his expression. Oh, you know he's got snot all up in that mask. Ugh. Oh God. glad I ate already.
All rise.
Thank you, everyone. Please be seated, and good morning, ladies and gentlemen of the jury. I know it's a little chilly in here. I'm not sure if that will change now that we're all in here. If at any time that temperature is too cold for you, let me know and we can have that adjusted. All right, Attorney Opper, you may call your next witness.
Thank you, Your Honor. The state would recall Detective Tom Casey.
Good morning, Detective Casey. Please make your way to the witness stand. When you get there, please remain standing. Raise your right hand, and Teresa will swear you in.
Do you solemnly swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you, sir. Please have a seat. Please state your first and last names for the record.
Thomas Casey.
Thank you. Go ahead, Attorney Opper.
Thank you. Detective Casey, I'd like to begin by asking you to refer to the item behind you. There's a large poster board there. If you could please place that on the easel and identify the exhibit number for the court.
It's exhibit number 15.
Thank you. And we've had testimony about this exhibit throughout the trial. Is that right, sir?
Yes, we have.
All right. Your role in this case was what, sir?
Objection leading.
Overruled.
Initially, I was on traffic control for the parade. Shortly after the incident happened, I was assigned as lead detective for the case.
Were you the individual who created this map, State's Exhibit number 15?
Yes, I did.
Okay. And I would like you to talk a little bit about how victims were identified in this case.
Objection leading.
Overruled. Foundational. The witness may answer.
So, at least initially, can you tell us, like, in the day or two after the parade, what happened?
Objection leading.
Overruled. You may answer.
So initially, that night, we knew that the victims were taken to different hospitals around the area, generally 5 different hospitals. So at the beginning, we began by having detectives assigned to each hospital. Waukesha Memorial Hospital received the most patients, so they also had a lieutenant that was assigned there as a team leader. As the patients came in, they were identified by detectives. The hospitals also provided us with lists of patients that they had, and we went through those lists and tried to identify people that came in and were being treated.
And then eventually, were there follow-up interviews conducted with these individuals?
Yes, there were.
What if the individual was a person under the age of 18?
Objection leading.
Overruled. You may answer.
If the person was a minor under 18, then we would reach out to their parents, talk to the parents. Some of the kids weren't able to talk to us, but we got the majority of their statement from their parents.
Okay. And do you believe that the names on Exhibit 15 truly reflect all the injured victims that you were able to identify in the course of this investigation, sir?
Objection speculative.
No, I do not.
Hold on. There's been an objection.
God.
It's overruled, and the witness will repeat his answer.
No, I do not.
Can you explain that?
Objection leading.
Overruled.
Just because of the scope of the investigation, we had so many people that were hurt, we had to come up with some kind of parameters to limit the people that we would call victims. One of those parameters is that they had to receive treatment at a hospital. Another one is that they had to be in the street when their injuries occurred. So there are some people that were injured, maybe on the sidewalk, trampled by the crowd, or received injuries that they didn't get hospital care from. You know, and unfortunately I learned later on there's even a person that was in the band that somehow we missed her being reported that she received a broken leg. So there are some that are not on the map, but all the people that have been charged are on the map.
So you mentioned people on the sidewalk. We did have some spectators testify in the trial, correct?
Objection leading.
Overruled foundational.
Correct, but they were more in the roadway or on the curb, not on the sidewalk, or not running away from the incident when it happened.
I see. So was, in your mind, when you were leading this investigation, trying to identify victims, what was the importance of the SUV in the injuries that were caused?
Objection leading.
Sustained as to the form of the question. Please rephrase.
Why were the spectators that are on this map included?
Because they were directly contacted by the SUV that came down the street.
If a person were injured because they were trampled by the crowd, are they on this map?
We exclude those.
Overruled. The detective may answer.
Those people were excluded from the map.
There were some people like that, right?
Yes, they were.
Okay.
Please make
Sorry.
sure. Thank you. I'll allow his answer to stand. Next question.
All right. I'd like to put up for you exhibit number 32, which has been previously identified. I'm sorry, admitted.
I'm sorry, you said 32? Yes. You said
Yes.
32? Okay, thank you. Sorry, I just missed it. Just to the witness or published, because it's been received?
Yes, we are going to publish this, Your Honor.
Go ahead. Permission granted.
Okay, thank you. And while we're waiting for it to come up in the jury box,
I don't have it on my screen.
It may take a second. Hold on. If it's not, let's check the cables.
We don't have it either.
I can see it. The witness can see it. Go out it. Thank you for letting us know, sir.
it's just the front tables, back tables on, Your Honor.
Hold on. Stop source for a second.
Mr. Entitled, put your damn eyebrows down.
No. Anything? Yeah. You can see it on the screen though, right, sir? On the there's screen, obviously, on the far side of the courtroom, and then to your right.
It's always better on here because
I understand. We'll get our tech guy over here to look at it, but it's previously been received, and we can see it on the two other monitors. So for now, we're going to continue. If there's anything new, I'll make sure to pause. Go ahead.
Detective Casey, I want to focus your attention specifically as to the extreme dance team. We heard testimony about several of the girls on the team being struck and injured. Do you remember that testimony, sir?
Yes, I do.
Overruled. It's foundational. The answer may stand.
Do you know if there were other people associated with the extreme dance team that were injured?
objection speculative.
Overruled. He may answer.
Yes, I do.
And do you know the names of these people?
Objection. Hearsay.
Overruled. He may answer.
Yes, I do.
What were their names, please?
Kathleen Pellmeyer.
Speculation.
Overruled. He may answer.
Go ahead, sir.
Kathleen Pellmeyer, Jennifer Stover, and Mitchell Lampine.
What was their role with the dance team?
You gotta love Detective Casey.
Jennifer and Kathleen were support people. Jennifer's daughter was marching the parade. And then Mitchell was there to hand out candy with his stepmom.
Okay. I'm going to now play, it's still not being displayed on our tables, Your Honor, but it is displayed on the two large monitors in the courtroom. So do I have permission to proceed?
Which exhibit?
This is 32.
Oh, yes. If we get to a new one that hasn't previously been received, then
Yes,
I will
okay.
pause to
All
get
right.
the tech people in.
All right. And
Go ahead.
Objection to relevancy.
Overruled.
The bailiff confirmed it's on in the jury box, Your Honor.
Thank you.
All right, please play. From the 32-second mark, I'm sorry, 35-second mark to 47 seconds.
How long is the exhibit?
Looks like it's a minute 23 according to what I can see on my monitor.
Definitely.
It is 123 total. We're only playing this 12-second clip from 35 to 47.
Thank you.
And please pause. Do you see any of the individuals you were just testifying about enter the screen, sir?
Objection speculative.
Overruled. He may answer.
Yes, I do.
Could you identify them by using the touch screen?
Objection leading.
Overruled. He may answer.
I'm gonna draw one big circle.
Okay?
It has two individuals, it has Jennifer and Kathleen. Kathleen has the red jacket on, and directly to her left would be Jennifer in a black jacket.
Okay. A little hard to see right now, but as they
It's very hard to see.
Shut up.
as they
Keep going.
walk, could you see two people walking there, sir?
Yes, ma'am.
Okay. Please clear the screen and continue playing. And pause. And I'm sorry because I can't see the counter. You're
It is at 44 seconds.
44 seconds. Thank you. Paused at 44. Do you see anybody else that you just testified to in the video at this point, sir?
Objection speculation.
Overruled. He may answer.
Yes, I do.
And who is that?
Mitchell,
Objection.
Overruled.
Mitchell Lampine.
Pain.
Please circle Mitchell. Do you know Mitchell's approximate age?
Objection speculative.
Overruled.
I believe he's about 10.
Okay. All right, we can take down 32. Did this video goes on to show the red SUV drive through the Extreme Dance team, correct?
Objection leading.
It's foundational here.
Overruled. It's foundational. It's previously been received. Go ahead.
Yes, it does.
To your knowledge of this video, sir, did those individuals, Mitchell and Ms. Stover and Ms. Pellmeyer, remain along the left side of the road there as the SUV went through?
Objection leading.
Overruled. The witness may answer.
They were hit by the vehicle and then moved to the left.
Let's take a pause for a second. We
Yes.
are IT experts. Hopefully I can get this figured out.
It's a lot of pressure.
Go ahead.
Could you put something on the screen that's okay to you for the moment?
Next one will be 132 if you want to. No, I'm sorry, 55.
It's on our screen.
It's on now.
Hold on, let's make sure. Do you have it now, sir? Yes?
Yes.
Oh, good, great. It's on mine, it's on the witness.
Do they have it too?
All right.
Just
Thank
like
you.
real life. You call the help desk and they show up and now it works, yeah.
Jury monitors, we're working. It's not, hold on, let's make sure. It was just working. There's a delay.
Well, maybe next time I'll just take that. It was done. The whole, take down the whole thing back out.
Is the law?
It can take 30 seconds.
What exhibit is this one?
This is 55.
All right, it's not. Very good. We're up and working. And 55 has previously been received, so go ahead.
All right.
Objection to the relevancy of 55.
Noted. Overruled. Go ahead, Attorney Albert.
Detective Casey, Exhibit 55. Can you see at the end of the road there, or the top of the screen, What unit is involved in Exhibit 55, please?
Yes.
Please tell us.
Objection leading.
Overruled.
It is the dancing grannies that are approaching from the right.
Okay. And one of the dancers, we have her testimony that was involved with the grannies was a woman by the name of Lola Hospital. Is that correct?
Objection leading.
Overruled. It's foundational. The witness may answer.
Yes, she was.
Is there video showing Miss Hospital being struck by the SUV?
Objection leading.
Sustained is to the form of the question. Please rephrase.
Sure. Is the exhibit, you've seen Exhibit 55 before?
Yes, I have.
Are you able to identify Miss Hospital, I'm sorry, yes, Lola Hospital in Exhibit 55, sir?
Objection leading.
Overruled.
Yes, I am.
All right. We're going to play the clip, Your Honor, from from 4 seconds to 8 seconds at 50% speed, and it is zoomed in on the middle of the road where the dancing grannies are located.
All right, go ahead. Thank you.
Please describe for the jury what you just saw in the video, sir.
Objection leading.
Overruled.
I saw the red SUV driving westbound on Main Street, approaching the dancing grannies and hitting Lola Hospital and then striking 2 other dancing grannies.
When you say hitting Lola Hospital, what did you see?
Objection leading.
Overruled. You may answer.
I saw the left side of the car come in contact with her, and then her body moved to her left after.
Did Miss Hospital report any injuries to the Waukesha Police Department?
Objection leading.
Overruled. The witness may answer.
Yes, she did.
All right, sir. I'd like to now ask that Exhibit 118 be published for the jury. This has previously been admitted.
Permission granted.
Objection to the relevancy of 118.
It's previously been received. Go ahead.
Sir, do you recognize the item shown in Exhibit 118?
Yes, I do.
And in addition to the photograph, if you had an opportunity to examine that item or items
Objection leading.
personally,
Overruled. The witness may answer.
Yes, I have.
and Mr. Johnson from the crime lab testified about these items yesterday, but I'd like you to tell the jury what you remember of these items, please.
Objection leading. Form of the first part of the question.
Overruled. The witness may answer.
So this is the red SUV that was used in the parade attack. This is a picture of it taken after. I remember a hood from a white jacket and a hat, a black hat with snowflakes on it, being pressed in between the hood and the windshield wiper of the vehicle.
Objection to it being called an attack. I think that's a disparaging remark for the record.
Your objection is noted, and the answer will stand. I will instruct the witness to simply describe what he's seen
He says,
without
but I got that one in.
further characterizing
Yeah,
it, because it will be up to the
Detective
jury
Casey.
to determine the facts in this case. Go ahead.
It was an attack.
When you saw these items on the hood of the red SUV, did you later come to recognize where they may have come from?
Objection leading.
Overruled. The witness may answer.
Yes, I did.
What did you determine?
I determined that they were the jacket, hood, and hat that Virginia Sorensen was wearing while she was walking in the parade.
Like to display to the witness only, please, Exhibit 177. This has not yet been received, Your Honor.
All right, go ahead, please.
Is 177 on your screen, sir?
Yes, it is.
And what do you see in Exhibit 177?
Objection, lead.
Overruled.
I see two dancing grannies carrying a Milwaukee Dancing Granny sign, and the woman on the left is Virginia Sorensen, and she's wearing a black hat with snowflakes, wearing a white jacket with a hood on it.
Move to admit 177 and permission to publish, Your Honor.
Objection to the relevancy.
To
The objection is overruled. Exhibit 177 is received. Permission to publish is granted.
Is that
relevancy.
177?
177, yes.
Relevancy is you ran over her.
Go ahead. And if the jurors would let me know when it's in the jury box as well, please. All right, thank you, it's there.
And again, just so we're clear on the record, please circle Virginia Sorensen and the hat in this picture.
Objection, lead.
Overruled.
That is Virginia, and then this would be the hat and hood that I believe was found on the SUV.
Knocked it right off of her. Awful. Awful.
Detective Casey, there were many videos that have been shown to this jury, correct?
Objection, lead.
It's foundational, Your Honor.
Overruled. The witness may answer.
Yes, there has been.
To your knowledge, are there any videos that display the license plate of the red SUV as it goes along the parade route?
Objection, lead.
Overruled.
Yes, there are.
Is it possible to capture a screenshot from those videos to see the license plate of the red SUV along the parade route?
Yes, there are.
I'd like to display for the witness only, Exhibit 150.
Go ahead.
Is 150 on your screen, Detective?
Not yet.
Okay,
It is now.
all right. Do you see Exhibit 150?
Yes, I do.
Please describe what you see in Exhibit 150.
Objection, lead.
Overruled.
I see the red SUV that was driven through the parade route, and it's at the time when it was contacting the Waukesha South band members. In that photo, you can read the license plate number.
Do you believe this photo is a true and accurate representation of the events of the day?
Yes, I do.
Move to admit 150 and permission to publish.
Objection. How does this go to investigation? Exhibits.
Overruled.
Investigation.
Exhibit 150 is received. Permission to publish is granted.
I believe it displays his license plate, right?
The image is a little blurry, correct?
A tad.
Can you please point out the license plates in the photo and read it for the jury?
It's okay if I circle it?
Yes.
Overruled. You may do so.
That is the license plate number, and I read ADP 9256.
All right. Now I'd like to show to the witness only number 151, please.
Go ahead.
Please describe 151. Oh, please clear the screen, Madam Clerk.
This photo is of the red SUV on the parade route, It's just photo taken just prior to the Bears Logistics float, and the band director is in the lower left-hand side of the video. It shows the red SUV with the license plate number displayed.
Do you believe this photo represents a true and accurate depiction of the events of the day?
Yes, I do.
Move to admit 151 and permission to publish, Your Honor.
Objection to relevancy.
Exhibit 151 is received, permission to publish granted, the objections noted and overruled.
I recall this state saying they had 140 exhibits. How do we get this many?
What the hell?
Keep going, Attorney Yopper.
Detective,
Seriously.
please describe what you see in 151. I think you did describe it. Strike that. Please circle the license plate and read it for the jury.
Objection leading.
Overruled.
ADP 9256.
Thank you. It's still not up. Okay, I'm sorry. Gotta wait for the jury.
Go ahead.
Detective Casey, during your investigation, did you uncover any other videos linking Mr. Brooks to this same vehicle with this same license plate?
Objection. I don't consent to being called their name and it's leading the witness.
Overruled as to both counts. You may answer.
Yes, we have.
Could you describe this video for us, please?
Objection leading.
Overruled.
There's a video that we obtained from social media that shows Mr. Brooks standing next to the SUV, and you can clearly see the license plate number on the vehicle. I believe the video was taken sometime prior to November 21st, 2021.
Okay, I'd like to display for the witness only Exhibit 175, please.
Go ahead.
Please identify 175.
This is
Objection. Relevancy.
Overruled. You may answer.
This is a photo. There's two individuals in the photo. The individual on the left, I know to be the person referred to as Darrell Brooks. It displays a vehicle, a red Ford, and it has the license plate number, which is displayed in the photo.
What is the source of this photo?
Objection leading.
Overruled. The witness may answer.
We obtained it through social media.
Okay. I mean, this is a photo versus a video.
This is the photo taken from
Hold
the
on.
video.
I understand the objection. It's sustained. It's foundational. This particular question, the witness may answer. Go ahead.
This is a,
Overruled or sustain?
Overruled.
You said sustain.
What did I say?
Yes.
Sorry. I meant it's overruled. The witness may answer. Sorry. I'm taking notes. I was writing the word source, and I think that's why I did that. In any event, go ahead and answer. Sorry about that for any confusion I may have caused.
this is a screenshot taken from a video.
Move to admit 175 and permission to publish, Your Honor.
Objection to that. What's the relevancy? I don't see the alleged defendant in here.
No, boy.
Your objection is noted. It is overruled, and Exhibit 175 is received. Permission to publish is granted.
Where's, oh, sorry.
The jury would also let me know when it's in the jury box monitors or on the jury box monitors. All right, go ahead.
Detective Casey, is person you know as Darrell Brooks in this photograph?
Objection. I don't consent to being called their name and leading the witness.
Overruled. The witness may answer.
Yes, he is.
Please circle or X or mark in some fashion. How do you know that's Darrell Brooks there? His back is to us.
Objection, leading.
Overruled.
I've watched the video in its entirety and I have seen his face in the video.
Okay, that can go down, please. Detective Casey, in total, how many videos do you think were collected by the Waukesha Police Department during this investigation?
Objection, speculative.
Overruled. You may answer.
We have at least 65 to 75 files. Some of those files contain multiple videos, photos, could be 10 each, so I would say probably 300 to 400 videos we have collected.
What were the source of those videos?
Some of the videos came from different people that were at the parade. Some of them are from city-owned cameras, and some of them are from fixed surveillance systems from businesses that were in downtown Waukesha.
Were all of the videos that were available shown to this jury?
No, they were not.
Objection, leading.
Overruled. You may answer.
No, they were not.
Have you personally observed and reviewed each of the video files available in this case, sir?
Objection, speculative.
Overruled. You may answer.
Yes, I have.
To your knowledge, sir, did any video ever show a different person behind the driver's wheel of that red SUV?
Objection, leading.
Overruled. The witness may answer.
I have never seen anyone driving the vehicle besides the defendant in any of the videos that I looked at.
In any of the videos, were you ever able to see multiple people inside the vehicle?
Objection, speculative.
Overruled. The witness may answer.
None of the videos that we have looked at showed anyone else in the vehicle.
Do any of the videos at any point show the red SUV coming to a stop, a complete stop along the parade route?
Objection, leading and
Oh.
speculative.
Overruled. The witness may answer.
I've never seen a video that shows the vehicle slowing or stopping while it was on the parade route.
Do any of the videos show the driver of the vehicle exit the vehicle to check on a person who had just been struck by the vehicle?
Objection, leading.
Overruled. The witness may answer.
I never observed in the videos the driver of the vehicle to stop and check or exit the vehicle on anyone.
There was testimony earlier in this case about witnesses observing multiple people running from the car. Do you remember that?
Objection, leading.
Overruled. The witness may answer.
Yes, I remember that.
Were there multiple reports like that, sir?
Initially, there were some reports like that.
When the vehicle was found on Maple Street, you weren't there.
Correct.
Objection, leading.
Overruled. His answer may stand.
Do you know what police activity occurred when the vehicle was found on Maple?
Objection, speculative. He just stated he wasn't there.
Overruled. The witness may answer. He was asked, what does he know?
Yes, I do.
Please tell the jury what happened when the SUV was found on Maple.
Objection, leading.
Overruled. The witness may answer.
Initially, Officer Moss went, he secured the vehicle, did not find anybody in the vehicle. There was an initial report that saw some other people running from the area of the vehicle. After that information was given back to us, we sent detectives down to the area to investigate further to see if we could corroborate and find out if that was true or not.
After that investigation, did you have other suspects or just one person?
Objection, leading.
Overruled. The witness may answer.
Based on the information of what everybody saw on the parade route, and then the detectives that went back down to Maple Avenue where and interviewed the people that reported the people running. Our investigation determined that there was only one person in the vehicle and there was no other suspects that we were looking for.
At some point in your investigation, Detective Casey, were you given a Ford key?
Objection, leading.
Overruled. The witness may answer.
Yes, I was.
What was your understanding as to the source of that key?
My understanding that that key was taken from Mr. Brooks when he was taken into custody and turned over to Detective Stern and Detective Carpenter.
Objection, I don't consent to being called that name for the record.
Noted. Overruled.
How did you get it?
One cares.
Objection, leading.
Overruled. The witness may answer.
You just stated how I got it.
Overruled. He may answer.
Detective Stern brought me the key the morning after the incident.
Did you do anything with the key?
Yes, I did.
Tell the jury what you did, please.
Objection, leading.
Overruled.
At that point, the vehicle was at the Waukesha County Sheriff's Department Secure Storage Facility. Mr. Johnson was over there processing the vehicle. I went there and I took the key with me and I checked the vehicle to see if the key would work in the car.
What did you find?
Objection, leading.
Overruled.
I found that the key worked the door locks to unlock the car. I also put the key in the ignition and it turned the ignition lock.
Thank you. Detective Casey, you've heard testimony about the manner in which the defendant was identified by the name of Darrell Brooks. Do you recall that testimony, sir?
Objection, I don't consent to being called that name, misleading the witness.
Overruled. Foundational. The witness may answer.
Yes, I do.
Did you endeavor to verify the identification of the subject you had arrested for this incident?
Objection, leading.
Overruled.
Yes, I have.
Did you verify his identity by the name of Darrell Brooks?
Objection, I don't consent to being called that name,
Well.
leading.
Shut up.
Overruled. The witness may answer.
Yes, I have.
How did you do that?
Objection, leading.
Overruled.
There were a couple different ways. One way is when a person is taken into custody, we take their fingerprints. We check that against other records that are kept by the state. Those fingerprints matched Darrell Brooks. I've also spoken to 3 women that he has children with. They verify that that is his name that he has always gone by. I have also spoken to his mother, which states that that's the name that he has gone by always.
Ouch.
I'd like to put on the screen for the witness only Exhibit 88.
Go ahead.
Do you see Exhibit 88, sir?
Yes, I do.
Objection to this, what was the relevancy?
Overruled. Go ahead.
Grounds for an overrule.
Relevant.
In what way is it relevant?
Shut up.
To the counts alleged in this case. Go ahead.
Can you please identify Exhibit 88, sir?
This is a bail bond through Milwaukee County Circuit Court for Darrell Edward Brooks, the date of birth of 2/21/82.
To your knowledge, was Mr. Brooks on bail through a Milwaukee County case on the date of November 21, 2021?
Objection, leading.
Overruled. The witness may answer.
Yes, he was.
And what is the date of this bail form, please? I believe it's near the bottom.
The date on the bottom
Objection leading.
Overruled, the witness may answer.
2/21 of 2021.
Was Mr., we'll strike that. By classification, can you tell us the level of charges that Mr. Brooks was pending on for this bail?
Objection. You already made a ruling on it.
Overruled, the witness may answer.
All the charges that I see in here are felonies.
To your knowledge, was this bail in full force and effect on November 21 of 2021, sir?
Objection.
Overruled. You may answer.
Yes, it was.
And in the middle of the form, do you see the conditions of bail that were set upon Mr. Brooks?
Objection leading.
Overruled.
Yes, I do.
And I'm looking under paragraph B, the third bullet. Do you see that?
Yes, I do.
Could you please read that bail condition to the jury?
Objection leading.
Overruled, the witness may answer.
The state defendant shall not commit any crime.
Thank you. Move to admit number 88, Your Honor.
Objection.
Exhibit 88 is received.
I'd like to display for
You already
the,
speculated to, how's that coming into evidence?
Overruled, and permission to publish.
I'm sorry, I did not seek to publish this, Your Honor.
Oh, all right, turn that
I
off.
request a legal finding of fact for that.
Oh, shut up.
The objection is noted, it's overruled. Continue, Attorney Hopper.
Thank you. I'd like to display for the witness only exhibit 89.
Go ahead.
Sir, can you please identify 89?
Objection.
Yeah.
Overruled.
Relevancy.
Overruled.
This is a,
This has been speculated, stipulated to as well. How's it evidence? How's it being admitted?
The objection's noted, it's overruled. The witness may answer.
I request a legal finding of fact for that too.
Shut up.
Noted, overruled. Go ahead.
Gosh.
this is a bail bond through Milwaukee County Circuit Court for Darrell Edward Brooks with the date of birth of 2/21 of 1982.
Is this a different case than what was displayed in exhibit 88?
Objection leading.
Overruled.
Yes, it is.
Are you able to make any observations about the level of charges related to this case, sir?
Objection leading.
Overruled.
It appears that there's 4 charges, 2 of which are felonies.
Okay. And on the bottom of the form, can you tell the date that this bail was issued?
Objection leading.
Overruled.
States 11/11 of 2021.
The, directing your attention again to that same location in the middle of the page under paragraph B, the third bullet. Could you please read the conditions of release that were set by the court in that case?
Objection leading.
Overruled. The witness may answer.
Defendant shall not commit any crime.
To your knowledge, sir, was this bail in full force and effect on November 21 of 21?
Objection speculative and leading.
Overruled as to both. The witness may answer.
Yes, it was.
Finally, sir, I'd like to put up one last item for you, or 2 items. 1 second, please. I'd like to display for the witness only exhibit 13.
Objection. What's the relevancy of this? How does it say any foundation to
Shut up.
testimony?
I'll give the state some leeway to establish that. Go ahead.
Sir, do you recognize can you tell if exhibit 13 is a video, sir?
Yes, it is.
Okay. Have you seen this video before, sir?
Objection leading,
Overruled.
still relevancy. Where's the relevancy?
The state is asking the foundational questions. The objection's a bit premature. I'll take it under advisement. Go ahead, Attorney Opper.
Yes, I have.
What does this video depict?
Objection leading,
Overruled. The witness may answer.
objection speculative.
Overruled. Go ahead.
This video depicts the backyard at 4014 North 19th Street in the city of Milwaukee. It also, that's the address of Dawn Woods, the mother of Darrell Brooks. And on the lower left-hand corner, you can see a Ford Escape.
In the lower
Objection.
right,
I move to strike that. How does he know? What?
The objection's noted. Overruled. You can ask him on cross-examination. You can question him about that. Go ahead.
the bottom right-hand corner of
Getting
the
nervous.
exhibit, do you see a date and time stamp for this video, sir?
Objection leading,
Overruled.
Yes, I do.
What does it say?
It says 11/21-2021, and then it says 13:26:18.
What do those numbers represent, sir?
objection leading,
Overruled.
To me, it means that the video was taken on November 21st, 2021 at 1:26 p.m.
And do you believe this video is a true and accurate representation of the events of that afternoon at that location, sir?
objection speculative.
Sustained. If you could lay a little more foundation.
Sure.
please.
How did you come into possession of this video, sir?
The defendant's mother provided it to us.
Ooh, Mama Dawn.
And do you know approximately when it was obtained?
Objection speculative.
Overruled.
The evening of November 21st, 2021.
Do you know if the defendant's mother was cooperative with police in providing the video?
Objection relevancy.
Overruled. The witness may answer.
Yes, she was.
Ooh, she was
Do you know
cooperative.
if the video was provided to police when asked?
Objection leading,
Overruled.
Yes, it was.
Do you have any reason to believe that the video was altered or modified in any way before it was provided to police?
I do not.
Move to admit 13, Your Honor, and permission to publish.
objection. Where's the relevancy?
Noted. Overruled. Exhibit 13 is received. Permission to publish is granted.
For the record, this is a video, it's 49 seconds in duration. We're going to play it in full. There is no audio, and it will be played at normal speed. Oh, hang on, don't play yet.
Yes, if the jurors would let me know when the monitors are displaying the video. All right, go ahead.
Well, there he is. At Mama Dawn's house.
Detective Casey, were you able to see any emblem on the front grille of that vehicle as it drove away?
I would have to look at it again.
Okay, I'm sorry. Let me ask you this. Did you see any damage to the front end of that vehicle as it drove away?
Objection leading,
Overruled.
I did not.
Okay. I'm gonna put up the state's exhibit 14 now, please.
Go ahead. Just to the,
Yeah, just to the witness only, please.
thank you.
Do you recognize exhibit 14, sir?
Yes, I do.
What is the source of exhibit 14?
This is a still shot taken from the video.
The same video we just saw, number 13.
Yes.
Okay. Move to admit 14 and permission to publish, Your Honor.
Objection, relevancy.
The objection's overruled. Exhibit 14 is received. Permission to publish is granted.
Sir, do you see Darrell Brooks in this photograph?
Objection, I don't consent to being called that name. Again, for the record.
Noted, overruled.
Yes, I do.
Can you identify or, excuse me, describe the clothing items that you see him wearing in this photograph? Oh, it's not in the jury box yet, I'm sorry.
You can state your objection, though.
Leading.
Overruled. The witness may answer.
Mr. Brooks is wearing a red t-shirt, blue jeans, and he has blue colored flip-flops on with white socks.
And what's the date and time stamp for this photograph, please?
It's 11/21/2021 at 13:26:08 hours.
And that's what time, sir?
Objection, leading.
On the 12-hour clock.
Objection, leading.
Overruled.
That would be 1:26 p.m.
All right, thank you. Have any other questions, sir?
Oh boy, get ready, people.
We cross.
In the two exhibits we just watched, 13 and 14, do you see anyone driving a vehicle?
No, I do not.
Do you know if anyone's in the vehicle at the time that you see it pull away?
I would assume, based on my training experience, that when the vehicle pulled away, that there was someone inside the vehicle, because in order to move a vehicle, you have to manipulate the controls, the shifter, the brake, the accelerator. So my assumption is that someone is inside the vehicle doing that.
That wasn't the question. Do you see anyone in the vehicle?
I object, Your Honor, that was the question, and he's already asked and answered. The question is, anyone can be seen.
The objections. Not sure what the objection was, but the answer may stand. You can ask your next question.
Let's go back to exhibit 175. You pull that up for the witness.
Clicking.
Would the state please pull that up? Witness only or published?
Publish.
Okay, thank you. Go ahead. Jurors, let me know when it's in the jury box as well. All right,
Just-
go ahead. It's in the jury
You
box.
just testified that this was the alleged defendant. How do you know that? Can you see a face?
Which question are you asking? Those were two.
Can you see the face on the circled individual in that exhibit?
In this clip, I cannot see the face of the person that is circled.
So how do you know who it is?
I can tell who that is because I have watched this video in its entirety, and I can tell that it is you based on all of my contacts with you.
So why were there not any other exhibits that can give credibility to you positively identifying the individual in this video.
Objection, argumentative,
Grounds.
compound.
Sustained as to the form of the question.
Is it fair to say that this is the only exhibit photo from the video?
Go
Can
ahead.
you clarify the only one that is shown today, or the only one that has ever been taken?
The only one that's,
ever
the only
exists?
one that's
Could you clarify,
being
please?
shown right here today. Is this the only one that is an exhibit being shown here today?
Yes, this is the only one that we've shown today.
You know, at this point, this is where he's such an idiot. We all know he's going to open the door. And it's like, you don't see his face, but we all know there's one way to fix that. So I don't know, but that's the thing. He's so full of himself and so annoyed about being right and thinking that things aren't fair that he's not gonna just open the door. He's gonna open the windows, knock all the walls down. Come on in, people. Hey, but we'll just enjoy it.
And you can tell just from this exhibit exactly who that individual is.
I don't believe that was my testimony.
I'm asking a question.
From just looking at this, no, but I know from looking at the entire video that it's you.
We're talking about this exhibit that's being shown right now during your testimony, right now at this moment. Strictly that.
Could you ask your question, please?
I'm going to object, asked and answered.
Sustained as to the form of the question as well.
Would it be fair to say that from this exhibit 175 that they're looking at right now that you cannot tell who the circle individual is? Would that be fair to say?
That would be fair to say.
Can you clear the circle?
Thank you, Madam Clerk.
And do you recall what date you viewed this video, as you call it?
I have viewed this video multiple times. I don't recall the specific dates that I've seen it.
Was it relatively early on in the investigation?
There have been multiple times that I've watched this video. Some of them early, some of them as late as yesterday.
Do you recall seeing this video the same night of the incident or in the days following?
I did not see it the night of, but it would be the days following that I have seen it.
And at that time, did you have knowledge of who that?
Okay, I'm going to take a break for just a moment. I don't know if you all just heard that. I'm going to hopefully got to the right spot to play it again. Now, I cannot take credit for this. I happened to see it on another creator's video who follows Darrell as well. And it's I Am J9 Eve. And I think it was one of her viewers picked up on it. And maybe you all have too. But it's right during the point I'm getting ready to play that clearly Darrell left a tremendously loud fart that everybody can hear. And it's long. I mean, I can't figure it could be anyone else but him. And the sound sounds familiar to all of us because let's face it, we've all done it before. So if you've already, heard it, I know it's so childish, right? But I mean, it's very loud and I don't know how I could have missed it, but hey. Okay, so It might be a second here.
This video the same night of the incident or in the days following?
I did not see it the night of, but it would be the days following that I have seen it.
And at that time, did you have knowledge of who that vehicle belonged to?
Dude, you know, like, he stopped talking. And it's like, "Rrr." Did you? Oh my God, that is like so crazy. Okay, one more time, just to make sure we have it right? Okay, let me get back. Okay, sorry. But if y'all have already seen, or I guess we could say heard it, then it's just redundant. But I'm just amazed I never noticed. But clearly it had to be him because he did not speak until that long sound was finished. I know I always do this stuff before I eat. Okay, so hopefully it didn't go back too far. But let's, again, listen to Darrell Brooks, the musical.
I did not see it the night of, but it would be the days following.
I think we're
that I have
close.
seen it.
And at that time, did you have knowledge of who that vehicle belonged to?
It's like he's pitched.
Yes, I did.
I'm going to continue on now,
And
guys.
did you have knowledge of the usage of that video? I mean, the usage of that vehicle?
Ooh, video.
I'm
Freudian,
not
huh?
sure that I understand the question.
Did you have knowledge of who may have been using the vehicle?
Objection vague as to time.
Sustained as to the form of the question, if you could limit, perhaps direct him to a specific time frame regarding the use of the vehicle.
At the time of the incident?
Yes.
And what, and can you clear that? And
You're
what
so rude.
information was that?
Yeah.
The information that I had is at the night of the incident that you, Darrell Brooks, were the person that were operating the vehicle.
And who did you learn that from? And for the record, I don't consent to that name.
We don't really care.
Noted,
For the record.
overruled. Go ahead and answer.
Can you repeat your question, please?
He is so pissed.
I'm gonna go another route on this.
You done with the exhibit, sir?
But no, I'm not.
So rude.
So you're withdrawing your question?
Yeah, I'm going another route.
All right, thank you.
Yeah. Would have been nice if you'd gone another route on the night of the parade. Bozo.
You just testified to seeing the entire video that this steel frame exhibit came from, correct?
I testify that this came from the entire video, correct?
You said that you viewed the video in its entirety, correct?
The entirety what we recovered from your social media account. I'm not sure if there is a longer version someplace, but
Did you see the video in its entirety? The video that this exhibit came from?
Dear God.
yes.
And are these the only two individuals that you observed in that video?
They are the only two that I recall seeing in the video.
Did you ever inquire about the identity of this individual?
God.
No, I have not.
Why would he?
Can you clear that circle?
Please.
Madam Clerk.
Would it be fair to say that from looking strictly at the exhibit that we're viewing right now, that both individuals have the same hairstyle?
It would be fair to say.
Can we clear the X's
Please.
and clear the exhibit?
Please and thank
Go
you.
ahead. Thank you.
we go back to Exhibit 13, published.
Go ahead. The state would assist, please.
13. Can you play it? Well, just play it. I'll tell you when to pause if that's okay.
Go ahead.
It's not up yet.
Oh, thank you. We're gonna wait until it's in the jury file.
Oh,
Click, click, tap, tap. He is mad and nervous. But yet he still thinks he's so
Go
clever.
ahead, thank you. Just as a reminder, it's 49 seconds long.
I don't think I'm gonna need the. Well, I don't know. I might.
Just get on with it. We're sick of you.
Pause. Right there, the individual that you observe. Right here.
Yeah, that one. That's
Do
all.
you see them wearing a hoodie?
The person in that photo is not wearing a hoodie.
Do you see a hoodie anywhere present in this video?
These are such
No, I don't see a
dumb
video or a hoodie
questions.
anywhere in the video.
Can you take the X down?
Please. Sorry, I can't
From
stand
this
rudeness.
angle, it'd be fair to say that you can see the very front end of the vehicle, correct?
That is correct.
Can you see any windows or see inside the vehicle at that time? Or at the time that we're looking at right now?
You cannot see inside the vehicle at this time.
So it would be fair to say that just by looking at what we're looking at now, you wouldn't know if anyone's already inside the vehicle.
This has been asked and answered, Your Honor.
I'll allow it. The witness may answer.
This is a whole different.
I'm allowing it.
Oh, God.
Go
Because he
ahead.
went a different route.
That is correct. From this video, you cannot tell if anyone else is inside the vehicle.
So it would be fair to say that you're not sure.
It's fair to say that I am not sure.
Can we pull this down?
Please. Gosh. He is so freaking rude. Barking.
Wait. I'm sorry, Keith. Pull that back up for 1 second.
Please.
Same exhibit.
Same
Go
exhibit, 13.
All right.
Dear gosh.
The state would put that back
Right.
on display,
Okay.
and there you go.
The-
Do you want any
wait-
more of a plate or just the still?
We waiting for the jury, or do they?
It's up.
No, we don't need it played.
Do you need it to go to a certain point?
Yes,
All right. Do you know what point?
I'm about to do it right now.
Mm-hmm.
Looking at this house right here. Do you see an address posted anywhere on this house?
In the photo that you circled, no.
So it'd be fair to say that you don't know the address of this house.
Oh my gosh.
That is incorrect.
You just said that you don't see an address posted anywhere in this house. So from the vehicle, strike that, not the vehicle. I'm still looking in the corner right here.
And he's nervous. And clearly has an
From
upset
the video
stomach.
that we're viewing right now, do you see an address posted anywhere on this house?
I do not see an address posted in this photo.
So judging by this, well, actually it's a video, but judging
Yeah.
by this video,
Mm.
how can you know the address of this house?
Because I've been at this house before to talk with your mother. I've seen the address on the front of the house.
Judging by this video.
Hold on. You have to let him finish because
Yeah,
that was
please.
not the question you asked. You asked him how he knew. He can answer. Go ahead, Detective Casey.
I have been at this address before. I have spoken to your mother. I have been in the backyard of the residence. I've seen the address on the front of the house. I know this to be your mother's house. I recognize from this photo to be your mother's address at 4014 North 19th Street.
You recognize the house or the address? Because we don't see an address in this video.
I recognize this house to be that address from being there.
And had you already been there, as you say, and talked to people, as you say, before you viewed this video?
I believe that I saw the video first, and then I was at the address
So at the time that you saw this video, you didn't know whose house that was.
Oh my gosh. What does that have to do with anything?
That would be an incorrect statement.
You just said that you saw the video first before going to the house. Did you or did you not say that? That'd be fair to say.
I guess I'm a little confused in your question. We received the video. We know from getting it from the mother that she said that that is where she lives. So I knew that this was where she lives when I watched the video. That was clarified for
I
you.
follow you, but that clarification wasn't stated before. So that's fair from the clarification of how you just clarified it. Can you clear
Please.
the
Are you
circle,
done with
please?
this exhibit?
Yeah.
We'll take it down, thank you.
You made reference to the key being found. Did you yourself find that key?
No, I did not.
Were you at the scene where the key was found at the time it was found?
No, I was not.
So it'd be fair to say that you were told that a key was found.
Yes, I was told that a key was found.
So it'd be fair to say that you went off of what you were told. You actually didn't observe this with your own eyes.
What are you speaking of?
The key being found.
That is correct. I was told by two officers who I've worked with for a long time, and I trust what they tell me to be accurate.
You made reference to there being a couple, what's the word you used, a couple ways to identify individuals. And you stated that you had spoken with the mothers of the alleged defendant's children.
Yeah.
That'd be fair to say?
I believe I said I spoke with the mother of 3 of your children.
At that time, was the alleged defendant already in custody?
Yes, he was.
Wouldn't it have been easier to just use the fingerprints that were already obtained?
Please.
Like I said before, the fingerprints was one way. We also verified it talking to his family members that his identity.
Any reason why, or let me back up. Is it fair to say that there was more confirmation needed to identify the alleged defendant at that point, seeing as how the fingerprints were already obtained?
We were just being thorough. We were certain that it was Darrell Brooks that we had in custody based on his fingerprints and other information that we had. It was just a matter of being thorough and verifying the person that we had and the name that he goes by.
To be fair to say, fingerprints are pretty accurate though, correct? Would that be fair to say?
I think that would be fair to say.
Trying to tell the
So
man
it would
his
also
job.
be fair to say that there wouldn't be any reason why the alleged defendant that was in custody would be someone else. Would that be fair to say?
Would it? Look at those eyebrows. Aggressive motion. He just can't stand the fact that he went to. Yeah, he was saying, oh, yeah, because he didn't identify with that name. That's what I was getting at. But also, it's so stupid because it's just getting under his skin that he went to his mama's house and talked to the mama of one of his 3 kids or whatever. It's driving him crazy. He doesn't like that. But he's trying to, he's trying to say, well, wouldn't it have been better to do that? Quit telling people their job. Idiot.
That's compound and difficult to follow.
It's not compound. It's
Sustained
not
is to the
difficult to
form
follow.
of the question, sir. Please
That was
rephrase.
very clear.
Oh, shut
Sustained is
up.
to the form
No,
of
really,
question.
you babble on.
And where did the interviewing of the mothers of these children take place?
The mothers
If you
of the
recall.
children. Jeez.
I spoke to Jessica Macklin in Iowa at her residence. I spoke to Angel Fitzpatrick at her residence in
Whoa,
Menominee
whoa, whoa,
Falls.
whoa, 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 whoa. Can we strike that? Why do the names have to be stated?
Overruled, he was answering the question. His answer may stand, your request to strike is denied, and the witness may continue answering.
Yeah.
I spoke to Angel Fitzpatrick in Menominee Falls at her residence, and I spoke to Erica Patterson a number of times at various locations about you.
You said one of the mothers of these children you spoke to in Iowa.
Correct.
Why would you go all the way to Iowa?
Because initially you listed her as a witness on your witness list for court. So we went there and we wanted to verify what information she might have that she would testify to.
Just for the record, I don't recall listing anyone as a witness. Just for the record.
For the record, Mr. Brooks, you can't testify
Yeah.
at this moment. You'll have an opportunity
Exactly.
to choose.
He's still going to
I
try to
just
talk.
wanted that clear for the record since
It
what was
can't be,
said.
No.
it's struck from the record at this
I-
point because you're attempting to testify. The
I'm not
jury will
attempting to
disregard
testify.
that.
I just wanted the record to show
Nope. You are
that I have
testifying.
knowledge of doing that. And if
The jury will disregard those statements made by the defendant
If
as
something's-
that he is not testifying
He's sitting
and would
there
be
shushing
improper
him,
at
he
this
can't hear
time
me.
for the court to receive them.
I don't think a
Go-
record should be
next
made of
question, sir.
something that I didn't do.
Next question, sir.
It's ridiculous.
No, you're ridiculous. And your questions are
So
stupid.
you said you went to Iowa to try to find out what would be testified to. Why?
Objection, argumentative,
Grounds.
irrelevant, and calls for hearsay.
Grounds.
Sustained as to all basis. Next question.
Yep. Oh, he's going to get so mad. He's going to be so
Was
angry.
that an attempt to prepare for what might have been said?
I'll allow that. Okay, go ahead.
Yes.
Why would there be preparation involved in someone who might testify on an alleged defendant's behalf?
Objection, argumentative.
Grounds.
Overruled, I'll allow it.
We went there to speak with her, so if she came and testified, there wouldn't be any surprises. We also wanted to find out if there's any background information that she had about Mr. Brooks that would be helpful in our investigation.
Don't forget to drink or eat or inhale. I'm on number 7 now.
So you made reference to
Looking at the ceiling.
not being any surprises. Would it be fair to say that there was a little worry there?
Objection, argumentative.
Grounds.
I think
Sustained as to the form of the question.
they're all grinning. I
What
think
surprises were you referring to? What do you mean by surprises? No surprises.
Your Honor, I object to this entire line of questioning. This witness is not expected to testify. It's wholly irrelevant.
Well, he opened the door by
no, you're opening the door.
and saying where you.
I will allow one more question on this. Go ahead, you may answer.
Could you re-ask the question, please?
What do you mean by making sure that there were no surprises?
We wanted to make sure that there wasn't any information that we weren't aware of that may come up later that would be helpful in the trial.
It's interesting that he would say, it sounds like you're worried, when what would they be worried about? Darrell, you're the one who's worried. I know it. The bailiff behind you knows it. All of us know it. But go on. Go ahead.
Do you recall making an attempt to interview the child
Objection, relevance.
who was 7 at the time?
Sustained.
No, like you have anything
Next question,
to
please.
do with them.
Reason for the sustain, Your Honor?
Not relevant.
I hate when he does
was-
that.
The question was asked, does he recall?
Sustained. Next question,
Has
please.
nothing to do with
Grounds for the
anything.
sustain again?
Relevant.
How is it not relevant?
Shut
going, sir.
up.
Did you interview the child?
Same objection.
Grounds.
Sustained.
Grounds for the sustain?
Relevant.
It's very interesting that he would be so concerned about the 7-year-old child of the time. What about the one he ran over? As he would say, mind-boggling.
Why would you ask to interview the child?
Your Honor,
Oh my gosh.
objection. This
Sustained.
entire line of questioning is inappropriate.
Yeah.
Sustained. Move on.
I would
Still-
object that. Trying to
Seriously?
interview a 7-year-old child is
Sir, move on, please. 90611. It's also not
It's
relevant.
unbelievable he would say that.
That's not an evidence.
it was a tricky move.
Ooh, it's so tricky. How about your deadly move towards Jackson Sparks? Gosh. Oh my gosh. I can't stand this guy. Could y'all tell? Absolutely cannot stand him.
You made reference to, in regards to Exhibit 88 and 89, which were documents from an entirely different county. Do you work for Milwaukee County?
No, I do not.
So how did Milwaukee County, which is a different county, come into your investigation in Waukesha County?
Because your felon
May I answer?
ways.
With the understanding there are some limited
He's laughing.
pretrial rulings that
He's laughing because Darrell, he thinks that Detective Casey's opening the door, but Darrell's opening another damn door. But look at it, look at Casey. Casey's loving it. Let's just savor the moment. Okay.
that still are in play. Go ahead.
During the normal,
I'm sorry for interrupting. I started off by saying in regards to Exhibit 88 and 89. That's how I started the question, just for the record.
I know. I'm reminding the witness of the pretrial rulings.
Okay.
But he's still gonna push it. You know he is.
during the normal course of an investigation, we do background on a person to see if they have any open cases or any information that would be helpful. There is a computer system that displays what cases or charges are open for a person, and it is relevant because if you are charged in one county and you violate conditions of bail, you can also be charged in another county for those violations.
And in reference to having charges in one county and potentially being charged in another county, in reference to that, wouldn't you essentially have to violate the conditions in one county and strictly be charged in that county?
That is an inaccurate statement.
I'm thirsty.
You being in law enforcement for a very long time, it would be fair to say that you're familiar with the term double jeopardy, right?
Oh God.
I've heard the term before.
And what is your understanding of what that term means?
This is nothing
Objection,
to do.
irrelevant, beyond the
Grounds.
scope of the witness's knowledge, legal conclusion.
Sustained for all those reasons.
You're really going. You're
So when
really.
did you become the lead investigator in this matter?
That was about 8:30 p.m. on November 21st, 2021.
So same night.
Correct.
And whom were you made lead investigator by?
The command staff or Lieutenant Jerry Habanik.
Do you recall why you were tapped to be the lead investigator?
Because I was the most qualified person, had the most experience to take care of it. That's what I've been told.
Any other reasons besides that?
Also because I was at the parade route a little bit earlier and I had the most information out of anyone. It took a little while for the other staff to come in, so I already had a little bit of a head start with the information that I already had learned as being there at the beginning.
And that would be the information that you said you had more knowledge of than anyone else at that time. Would that be in reference to having an interaction with the vehicle at some
Yeah.
point?
I would say it was the totality of the situation. I was there when the car first went through. I know what the radio traffic was for taking Mr. Brooks into custody. There's also some decisions that were made early on how to proceed with the case. I was also on scene downtown and took control of the crime scene initially. So a lot of those decisions were made even before our command staff started coming in to take over lead on the case.
I mean, you referenced you were there at the beginning when the vehicle first entered in the parade. What do you recall about when the vehicle first entered the parade?
I remember a horn beeping, red Ford Escape driving around, and then you driving into me and not stopping when I pounded on your hood and window.
Driving into you, what do you mean?
What the hell do you think he means?
I meant I was in front of your vehicle contacted me, pushed me off to the side, and continued driving without stopping.
Were you injured in this incident?
I was not injured, thankfully.
And you made reference to a horn beeping. What do you mean a horn beeping?
Oh no, not the horn
I mean, a
beeping
horn
The
again.
vehicle was beeping its horn?
Yes, the vehicle was beeping its horn.
What would be the only time a vehicle would beep their horn?
Oh my
Objection,
God.
speculation.
Grounds.
Sustained. Calls for
Reason.
speculation.
He's already asked that before. Oh my gosh. And he really thinks he's getting somewhere, but he's just getting
Do you
further
know why a vehicle
and
would,
further
why the vehicle was
away.
beeping their horn?
Same objection, Your Honor.
Do you know why you would beep
He
your
asked,
horn?
do you know why? So he can answer that question.
Could you repeat the question, please?
Do you know why the vehicle was beeping its horn?
I imagine that the driver was angry and wanted to get through the crowd.
And how did you come to that determination?
Could it be because he was driving where everything was blocked off for the parade? And he looked like a raving lunatic? Just saying.
I've been driving a long time, and a lot of times people get angry, they're late, they beat their horn at you in a way that is because they're upset and they're trying to get past you.
Do you know that for sure?
Oh,
You asked me
God.
my opinion.
Yes, I did ask your opinion. Now I'm asking you, do you know for sure if the driver of the vehicle you observed was in fact angry?
based on the
I
massacre.
assume that he was.
So
do
it'd
you
be
know
fair
for
to
sure?
say you don't know for sure.
Ugh.
I do not know for sure, but that is my
Smack him
opinion,
when he
that
says
he
that.
was angry.
And at that time, you had no knowledge who the driver was. Would that be fair to say?
Well, I had knowledge because I saw your face. I did not know your name
Did
at
you
that
know
time.
who the driver was? No, meaning had you had any prior interactions with them before this incident? That's what I mean by no. Have you had any conversations with him, talked to him?
Hold
saw
on,
him?
compound question, ask one.
I was
Seriously.
just giving clarification of no.
No,
What I
you
meant by
know-
It's a compound question, please rephrase.
Before you observed this vehicle, as you say, this driver that, as you say,
As
did
you say.
know him?
Jeez.
I have no memory of meeting Mr. Brooks before that afternoon.
So it'd be fair to say that you're assuming something that you don't know. Would that be
Clicking.
fair to say?
Objection, compound, vague, and argumentative.
Sustained.
Grounds.
She just said why.
Sustained as to the form of the question.
Definitely being argumentative.
How would you know how someone's feeling
Oh my God,
if
stop.
you don't know who they are?
Your Honor,
Stop it.
he opened the door to this. It's asked and answered. The witness has given his opinion. It's clear.
Grounds.
I object. Improper question.
Yes.
Grounds.
I will allow the witness to answer
Oh my
why he came
God.
to that conclusion.
Jeez,
Go
man.
ahead.
Like I said before, I've been driving a long time, and a lot of times when people are beeping their horns, it's because they're late, they're angry at something happened, and that's why I concluded that the person was probably angry.
Let it
So
go.
would it be fair to say that another reason why a vehicle would beep its horn would be to alert people to the presence?
If that isn't the stupidest thing, well, no, he said many. Alert them of their presence and then you continue to mow over people? Oh my God. Can you imagine sitting in that jury box while he is going on? I really can't tell you how much I dislike this man. Look at him. Oh my God. Okay, here we go.
Objection,
Grounds.
irrelevant speculation.
Grounds.
I'll allow it based upon his training and experience. He may answer.
It's such stupid questions.
It's a possibility.
And did you hear this beeping before the vehicle approached
Oh
you?
my God, I can't believe the beeping.
Yes, I did.
Again, he's still doing nothing to help himself, to defend himself, to save himself or his client.
You made reference to, and I'm referring to the ring video obtained in exhibits 88, or I'm sorry, the ring video obtained in exhibits 13 and 14. You made reference to obtaining that the same night of the incident. Do you recall saying that?
Yes, I recall saying that.
And it would be fair to say that you yourself have been present for all testimony. Would that be fair to say?
That is not correct.
How so?
I was sick one day and I was not here.
Well, I'm referring to, let me clarify. Maybe I wasn't clear enough.
Oh, please don't.
Pertaining to all testimony since trial began, you've been present for all testimony. Would that be fair to say?
I believe I've seen most of it.
Do you recall testimony of and I'm referring to, again, So clear for the record, exhibits 13 and 14, ring footage that was obtained by the owner of 4014 North 19th Street that you testified to obtaining the ring footage the same night. Were you aware that, well, let me back up just a little bit.
God.
How were you able to obtain that ring footage?
There was officers that went to Freighter Hospital where Dawn Woods, Mr. Brooks' mother, was working. They spoke to her, and she's the one that alerted to them that she had ring video at the house. They offered to remotely download that video for them.
And were you there yourself?
I was not there myself.
He is such an idiot. So you don't know for sure.
When did you yourself speak to the owner of that home?
The last time that I spoke to Dawn Woods was on August 8th of this year. I may have spoken to her a few times before that. I don't recall the exact dates.
I'm referring to the first time that you spoke.
I don't recall
The
the
first time.
Shut up, Darrell.
I don't recall the first date when that was.
And you did just make reference to an August 8th date. And what was the extent of that conversation?
Objection calls for hearsay.
Grounds?
Sustained. Hearsay.
Just ask your mama when you talk to her tonight on the phone.
The August 8th date that you referred to, was that in any way follow-up? Was that follow-up investigation?
Follow up to what?
Well, you stated that you had spoken previously before the August 8th date. So the question is, was the August 8th date follow-up to the investigation that you were already actively lead of?
I mean, everything is related to this investigation. The
So-
investigation continues every day. It's not end. It will not end until this trial is over.
So what follow-up was needed at the time of the August 8th interview? I'm guessing that's what you would call it. I don't know, I'm not sure.
Objection still calls for hearsay, Your Honor.
Sustained.
Why did you need to talk to Ms.
Why?
Woods multiple times?
Because every time we spoke to her, we got different information, and at that time, we were following up with your niece and nephew of what their testimony would be in this case.
Oh boy.
What testimony are you referring to? Because I don't recall any nieces or nephews testifying.
Don't look at her.
I don't think I'm allowed to say.
I think this line of questioning is irrelevant, Your Honor.
I'll
Seriously.
sustain the objection, and at an appropriate break, I can address it further. if need be. Please move on to a new topic, sir.
You made reference to people who were injured at the parade inadvertently. You recall that?
Yes, I do.
To your knowledge, were any of those charged?
My testimony before is that those people's cases were not charged.
And were they seen as victims?
going to object to the form of that question. I think it calls for a legal conclusion, Your Honor.
It does not.
Don't know what you're-
I asked to his knowledge.
Oh, jeez. Please don't make him answer.
I'll sustain the objection as to the form of the question, if you could please rephrase.
Still has nothing to do with saving him or his client. Nothing.
I'm gonna go a different route.
Oh, here we go again. Another route. God help us all. Why do you have to announce that? You don't need to announce that. Just start questioning. Any day.
Do you recall serving a warrant to the Waukesha County Jail on July 1st of 2022?
Yes, I do.
Do you recall what that was for?
Yes, I do.
And what was that for? Can you state for the record and for the jury?
It's for Mr. Brooks's jail cell.
And why did you serve a warrant for a jail cell?
Your Honor, I object pursuant to legal rulings previously issued in this case. I don't think this is relevant.
I'll sustain the objection. It's not relevant. I'll certainly take it up at a later point if need be.
What was the warrant pursuant to?
I sustain the objection. Next topic, please.
You don't look like
You
a...
didn't answer.
I sustain the state's objection.
Yeah.
I've directed
She
you not to
sustained it,
answer.
fool.
We'll take it up separately. I'll have you continue with your cross-exam and I'll take it up later.
Look at... Oh, he's so pissed. The questions get more and more stupid. He's more worried about getting his gotcha moment with everybody else and trying to make them look bad and trying to protect his dreadful self. Come on, dig, 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 Darrell.
You made reference to this vehicle driving into you, but stated you were not injured. Did you file a claim in this matter?
No, I did not.
Do you consider yourself an injured party in this matter?
No, I do not.
Do you yourself know if anyone filed a claim in this matter?
Can you be more specific?
Do you yourself know if anyone filed a claim in this matter?
Just in general?
Whatever your interpretation of that will be.
I would say yes.
And do you know what that claim was?
I would imagine that there was a lot of injuries from the people. A lot of people had very extensive medical bills. I imagine that they would file a claim with their insurance company to have those bills paid.
So you had knowledge of what was filed to their particular insurance companies?
I have no knowledge, but my assumption is that they would have filed those bills.
So it'd be fair to say you don't know for sure.
That was my testimony.
Oh, gosh.
Is that the answer?
Yes.
He said that's his testimony. Ugh. It's painfully slow. Just digging.
As lead investigator for this matter, where are you, to your knowledge, aware of any GoFundMe type of things?
Objection
in relation to
relevant? I'm sorry.
Do you mean as it relates
as it
to,
relates to the incident?
overruled, the witness may answer.
I have no direct knowledge, but I assume that there are some GoFundMe pages out there. It's typical in something like this.
And what do you mean by typical? You've seen this before? Is that what you mean by typical?
We have a very loving and caring community where a lot of times when bad things happen to people, people pull together and offer financial assistance to help people.
Is it fair to say that there's a lot of communities like that across Wisconsin?
Yes, I think there are.
Hey, what's your point, Darrell?
It would be fair to say that you've worked extremely close with the district attorney's office during the entirety of this matter. Would that be fair to say?
The district attorney's office has been involved in this investigation since the night of, so we have worked closely.
So would it be fair to say extremely close, seeing as how you've been present for the whole trial pretty much?
Can you define extremely for me?
I would like you to.
Oh,
define
gosh.
extremely.
This is so ridiculous.
I'll answer yes if that helps.
Such a waste of time.
To your knowledge, do you know if it's typical for a lead investigator to sit right behind the prosecution table at a trial?
Yes, it's very typical. It happens in most larger cases, especially a case of this magnitude. There would be a court officer. So yes, that's a very typical thing that happens.
Have you ever done this before?
I've done this multiple times before.
And are you the only detective in the investigation that has that honor?
Objection vague.
Grounds.
Sustained as to the form of the question.
Are you the only detective directly involved in the investigation that sits with the prosecution?
Talking about this case or any case?
This particular case.
I'm sorry, you interrupted me. Could you repeat that, please?
I believe he said this case.
I'm referring to this case, yes.
Could you re-ask the question, please?
Are you the only detective actively involved in this investigation that sits with the prosecution in reference to this case?
Yes, I'm the only person, the only detective that's sitting with the prosecution during this trial.
So would you explain who the other officer is in the blue suit over there?
Oh my
Objection to
gosh.
the relevance, Your Honor. Sustained.
I just want to know his role.
Sustained.
He's
Next
your
question,
For the
please.
sustain.
Not relevant.
He's been in the courtroom the whole trial. How is it not relevant?
Mr. Brooks, next question, please.
Nobody knows who he is.
He's the bouncer of the courtroom. He's going to take your ass out when you misbehave. Excuse me. I mean, I'll be honest, I kind of didn't know who he was at first either, but clearly he's a detective. I know that. But, I mean, such a stupid question. None of these are helping. Nothing is helping him.
That should be known.
Please.
Nobody sits
It's not relevant to the issues that the jury needs.
Oh, he didn't have anybody sit behind him at his table. He's leaving out Mr. Bailiff. Who does he want at his? Who's going to sit at his damn table?
Determine. Next question, sir.
Is it asking or telling?
Oh man, I cannot stand him. Have y'all heard me say that before? Just he needs to, and the jury
So
is
that's
what.
asking.
See, and he thinks he's so cool for the jury. Wow,
You know what the other one would entail.
wow,
Um,
Do you
wow.
have a question, sir?
yeah, I do. I would like to get to it. Thank you.
Please do so. Thank you.
I will.
He's done that type of thing to her before when she said to go on with a question. That same thing. I'm getting to it if you'll let me. The jury, he thinks the jury, the jury
So seeing as how
is hating this.
set with the prosecution for the entirety of this matter, it would be fair to assume that you know who the plaintiff is in this matter.
Oh my gosh.
Yes, I do.
And who would the plaintiff be in this matter?
The state of Wisconsin.
Is that an entity or a living human being?
It's an entity.
How can an entity file a claim?
Objection,
Grounds.
legal conclusion.
Grounds.
Sustained.